this is a public service.
Your Honor, I realize you haven't formally called the case just yet. Once you've done that, but before we go into any factual presentation, I have a matter of law to bring up with you that would precede that.
Well, that's fine for you to have a matter of law, but I would prefer to do it this way. I will call on the city for their testimony as why the violation occurred. Then you may respond to that, and then you can give me any case law you want to at that time. That's the way I'd like to conduct it.
I understand that, Your Honor. I guess my concern is, first of all, that I was handed all the evidence about 9:58 this morning, and the statute clearly requires fundamental due process. I also have received no confirmation from them that they have submitted to you the materials that I submitted ahead of time. And besides all of that, in my materials, I mentioned that this case was actually brought illegally because Florida Statute 70.45 required them to issue a written response to me as to why they feel that I have caused a harm by these supposed violations, and how their proposed regulation is proportionate to the supposed harm that I've caused. Before they can continue with that, they are legally required to submit an answer in writing to me, unless they submit in writing to me something saying that they're no longer going to be pursuing that. Instead, they've totally ignored that. So this proceeding was actually commenced illegally. That's why I wanted to bring that up before they had the chance to continue with this, because it violates due process.
I will allow you to do that. We're at a limit for time. There are other matters that I will do this afternoon, and so I have to conduct the hearing the way that I think that it should be conducted. As far as the material which you had, that it was delivered to me Saturday about 2:30, and I have reviewed all that.
Okay, thank you, Your Honor.
Now, so specifically, you feel the hearing is not appropriate to be brought. Is that what it is?
That's one of my concerns, yes, Your Honor. That would be the concern that I feel it would need to be addressed at the onset of the hearing rather than bringing that up in the middle.
Yeah, okay. We will proceed with it.
Do you want me to? I didn't know if you officially called it yet, so I was just waiting.
Yeah, I'll call it. I think I already spoke, but I'll call it. Case number 22-11223, parcel 4223020600130. Michael Henry and Katherine Henry, P.O. Box 333, Ormond Beach, Florida. Location of violation 33 Cypress Circle, Ormond Beach, Florida. The alleged violation is no building permit issued as stated in the Land Development Code, Chapter 2, Article 3, Section 250N1A. Fence installed without permit. The second case is case 22-112-246, parcel 422303060130. Michael Henry and Katherine Henry, P.O. Box 333, Ormond Beach. Location of violation 33 Cypress Circle, Ormond Beach. No building permit issued as stated in the Land Development Code, Chapter 2, Article 3, Section 250, storage containers placed on the property without a permit. Third case is case number 22-112-247, parcel 4223020600130. Michael Henry and Katherine Henry, P.O. Box 333, Ormond Beach. Location 33 Cypress Circle, Ormond Beach, Florida. Violation, no building permit issued in the Land Development Code, Section 114.6A1, pavers installed without obtaining a permit. The respondent, Katherine Henry, is requesting the special magistrate to hear arguments that the city does not have the authority to proceed with this hearing. So I will allow you to do that now. What will you be doing? Submitting cases to me?
No, the statute I already submitted to you, Your Honor.
Okay, all right, I've read that. And then the city can respond to you. Pertaining to what happens there, then we'll proceed. Okay.
Yes, Your Honor. aside from the other legal issues that would be more relevant to talk about in the regular context of probably after the city has presented any evidence or arguments that they would like to present, the issue of this hearing starting and being set for a hearing is in violation of Florida Statute 70.45. Looks like I have a typo. It's supposed to be 45, not 445.
Say that again.
I just realized there's a typo at the beginning of my documentation I submitted to you. It's Florida Statute 70.45, not 70.445.
Yeah, okay, I see that in your
so I apologize for that. So the issue here is that with that statute, I mean, there's tons of Florida statutes that talk about why the proceedings in this manner shouldn't be going forward, and why our protections as homeowners are of the utmost concern with the legislature and how they have set out the Land Development Code and all the other related statutes. 70.45 specifically created a situation where if a homeowner, such as myself or the two of us, my husband and myself, think that the city is violating our rights as property owners, then we can file a written notice of proposed litigation or proposed action to the city, where they are legally required by the statute. They must respond in writing with one of two things. They either have to respond in writing saying, we have decided that it's in the interest of justice, that we're not going to pursue the case, and so we will take no further action in this matter. Or they have to respond in writing saying exactly what harm it is that our proposed use of our property has caused and how their proposed regulation of our property is proportionate to the harm that we're causing. There is no harm that our property is causing or our proposed use is causing, nor has it ever been alleged, because it's simply not the case. But instead of responding in writing as they are legally required to do, they instead instituted these proceedings and acted as though that statute didn't exist. They're cherry picking which laws that they're going to follow. And this is literally the statute 70.45. This type of hearing is precisely the municipal regulation that the state legislature says you have to put pause on what you're doing and provide this written response before you do anything else. And that way, if they respond in writing to me saying, oh, well, we think we have reason to do this because your 3 proposed uses cause harm in some way, and here's how they cause harm, etc., then I have the opportunity to, among other things, file a lawsuit against the city to stop them from pursuing this. But they did not afford me that opportunity and because there's not a specific deadline, I've been patiently waiting for the city to file their statutorily required response to me. So it would be premature for me to have filed a civil lawsuit against the city at this point. So this is really the only thing that can happen at this hearing, is that they be ordered to follow the Florida statute and file that written response to me, which, depending on what the response comes out to be, then I have the opportunity to follow the statute and file a civil case in the county circuit court. Otherwise, this hearing would be premature, and it would literally subvert the entire purpose of Florida Statute 70.45.
Can you refer me to sections in 70.45 that you think are pertinent to?
70.45, I mean, really the whole statute, it's not very long. The whole statute is relevant, so I'm not sure exactly how to best answer your question. Okay. But it starts with the definitions section, and this kind of thing would be a prohibited exaction, which is any condition imposed by a government entity on a property owner's proposed use of real property that lacks an essential nexus to a legitimate public purpose and is not roughly proportionate to the impacts of the proposed use that the government entity seeks to avoid, minimize, or mitigate. Obviously, attorneys wrote that because it's horribly complex, but that is what we're talking about, is prohibited exaction. And, sorry, that was subdivision 1D. Subdivision 2, in addition to other remedies available in law or equity, a property owner may bring an action in a court of competent jurisdiction under this section to declare a prohibited exaction invalid and recover damages by a prohibited exaction. And it says that at least, this is subdivision 3, Your Honor, at least 90 days before filing under an action under this section, but no later than 180 days after the imposition of the prohibited exaction, the property owner shall provide to the relevant government entity written notice of the proposed action, which is what I did on November 8th, 2022. This written notice shall identify the exaction that the property owner believes is prohibited, which I did. It's the 3 regulations we're talking about here today. Explain why the property owner believes the exaction is prohibited, which I did, and provide an estimate of the damages, which was attached. The government entity shall review the notice of claim, shall obviously is a requirement, and respond in writing to the property owner by identifying the basis for the exaction and explaining why the government entity maintains that the exaction is proportionate to the harm caused by my proposed use of my real property, or by proposing to remove all or a portion of the exaction, or in other words, dismissing the action against me. And even if, in the event that they wrote back and said, oh, well, sure, this is the harm that you've caused, and this is how our exaction or regulation of your property is, we believe, is proportionate to your loss of use of your own property. Even then, if I decide to then file that civil lawsuit against the city, the government, the city entity, has the burden of proving even in that action that the challenged exaction or the regulations that they've brought up here has an essential nexus to a legitimate public purpose and is roughly proportionate to the impacts that our supposed, our proposed use of our property, that they're trying to, the harms that our property is supposedly going to cause. And that's, I guess, something that's telling is that it's the government entity that bears the burden of proof in that sense. And the whole thing is, that goes to the point of 70.45 is written for a reason. We can't cherry pick which laws we're going to follow, which has been a problem in this case all along. But this one stops this proceeding from even taking place. So they have to respond in writing either way, and the statute is written so that if they respond saying, oh, we think we're legitimate in our, we're going to continue with this, then they have to lay out what harm I'm causing and why they think the regulation is proportionate to my loss of use of my property. And then I get to be able to file a civil lawsuit against them where they have the burden of proving that those conditions exist. So it's, are all of our statutes complex and complicated and found in way too many portions of Florida statute chapters? Absolutely. But that doesn't mean that we get to cherry pick which ones we're going to follow. And I followed this statute to the letter, and I would expect that the city has to do the same, Your Honor.
Okay, that's interesting, and I appreciate that. You're an attorney, so...
Not a Florida attorney.
You're not a Florida attorney. Anyway, do you know what a judge would ask you? Do you know of any district court cases in Florida or Supreme Court cases that I could look at pertaining to this argument that you're making?
This specific statute, or this? No, because I think that's not our job. When it comes to implementing the statutes, we have to implement them on their face. We can't simply ignore them. And that's the thing, is that when this has been brought up to the city for almost 4 months now, 4 months, never once have I received a response either that they thought the statute was not appropriate, or I've received literally zero response on this at all. The only response I ever got was when they were serving me with the notice to be here.
Okay. All right. Thank you. Is there a response from the city?
Yes, Your Honor. I haven't had an opportunity to review the full statute that she's mentioning, but it appears that this is the wrong forum to be arguing the application of this statute. That would be before the circuit court. This is not new legislation for the local government. This is not something that was created and now is affecting her rights. I believe she has lived in Ormond Beach no more than 2 years in at this property. These ordinances have been in effect long before this. All these codes have been long before. So she moved here with full knowledge, and she has not gone to circuit court to challenge these ordinances or code in the city. So I don't think she's in the right forum. There's no standing for this.
You want to respond to that?
Yes, absolutely, Your Honor. The problem is I wouldn't have standing to have filed a lawsuit against the city before this because there wasn't a government exaction under this very statute where they were attempting to do what they're doing right here. It would have been kicked out because it would have been premature. The only way that, I mean, it's pretty clear. And not having time to read the statute, it literally takes up 1 page, and they've had notice of this for 4 months. But this statute is pretty clear. It's not challenging necessarily a particular statute that it's, unconstitutional on its face. Maybe it's unconstitutional as applied. I mean, there could be all kinds of reasons why the proposed exaction is not appropriate under the statute. But that's not what the purpose of that statute is. And the statute doesn't mean that I have to then go and bear the burden of proving that a particular code is unconstitutional, either as applied or on its face. That's not the purpose of that statute. In fact, the statute is pretty clear that when they're trying to do this very thing, when they're trying to stop, I mean, look at what I was just served this morning, their proposal for if you should find in their favor what they're asking you to do. And just like the case right before us, they're asking that you issue the per day fines and that you allow them at as of April 10th to go in onto my property, removing my property. That's the epitome of, it makes no sense to say we have to go through all of this before I would then go and file a lawsuit. In fact, I have to file the written notice to them of the proposed litigation prior to going and filing the actual documentation in circuit court. Otherwise, they'd kick me out. They'd say, well, you didn't comply with the requirements. I did exactly what I was supposed to do, and the city, because they have absolutely no experience or know-how in dealing with 70.45, decided that they're just not going to touch it. They're just not going to deal with it. But that's not how this works. We have to uphold all the statutes.
Okay, so your argument is in the nature of a motion to dismiss this action. Is that correct?
Yes, Your Honor.
All right. Anything else from the city or from you arguing in this case? And a lot of the things which you have talked about are in your response, which I thoroughly looked through.
I guess just to clarify, Your Honor, the only thing I would say that I would be asking then in terms of looking at it as a motion to dismiss is that it be coupled with the city still has to respond one way or another in writing to this notice that I have served them. So I would ask not only that this action be, all 3 of these actions be dismissed today, but that they actually be required to submit the legally, statutorily required written response.
Okay, thank you. All right. After reviewing your written response and after hearing arguments, after hearing from the city of Ormond Beach, I find that your arguments are without merit and I deny your motion. And I'll proceed now with the testimony of the city of Ormond Beach. So who is going to that?
We're out here today to ensure our constitutional rights are respected by those that swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. This is a public service.